Good afternoon, ladies and gentlemen, and welcome to our webinar, which we're also going to release as a podcast. My name is David Pritchard, and I'm the head of marketing here at Sintons. I'm joined again by my colleague, Fiona Campbell, who is an associate in the employment and business immigration teams here at Sintons. Our recording today will last approximately 25 to 30 minutes. And consulting my notes, Fiona is going to discuss immigration for employers, which is an update on the new immigration rules that come into effect on the 1st of December 2020. So without any further ado, I'm going to pass you straight over to Fiona.
Hi, thanks for joining me. So today I want to talk to you about the changes that are happening as of 1st of December 2020 in relation to the immigration rules. Now I'm actually recording this on the 1st of December, so these are brand new changes just coming into effect today, so you're getting this hot off the press, so to speak. Now, this is one of these situations where doing this by way of a webinar is actually going to work really well for you, because what I'm going to do is I'm going to talk you through the main changes first, and then after I've gone through the main changes, I'm then going to go over the basics really for people who want to be a sponsor. So if you're already experienced sponsors, you can pretty much tune out after the first 5 to 10 minutes, and you're very welcome to log off after that. But those people who maybe want a bit more of an introduction to being a sponsor are very welcome to stay on for the duration of this webinar. Now, if you excuse me for just a moment, I'm going to go through the technicalities of sharing my slides with you. So just 1 second. Now, hopefully you can now see my slides. So there we go. Today's webinar is immigration for employers. So that's specifically who I'm targeting. And as I mentioned, specifically starting with the new immigration rules and then moving on to business immigration in general. Okay. First of all, as I said, it's the new post-Brexit immigration rules, and I will cover both the skilled worker route and the intra-company transfer route, although I will really be focusing on the skilled worker route today. And then I'll be moving on to giving you some guidance for being a sponsor. I'll explain how you apply for a license, how you sponsor a worker, and the sponsor's duties and how you comply with those duties. Okay, so first of all, those main changes that I've promised you. As you'll all be aware, we are coming to the end of this long Brexit process. And obviously this is going to have an impact on those people who are EEA or EU citizens currently living and working in the UK, and obviously those who move here. Now, those citizens who move here by the 31st of December can apply for pre-settled or settled status through the EU settlement scheme. EU, EEA or Swiss citizens arriving in the UK after 11 p.m. on the 31st of December this year will then need the appropriate sponsorship if they want to work in the UK. Basically, they're going to be treated the same as anyone outside the EEA. Irish citizens are excluded from this as they don't need permission to live and work in the UK. One of the main changes is going to be that it's going to be simpler for people to make applications with from inside the UK, as previously really, but a bit more prescriptive. Evidence of English language will be required as a condition of most visa applications. And exemption from that is intra-company transfer route. Okay, looking specifically at the skilled worker. So it's a rebrand of Tier 2 and will be the UK's main sponsored work visa routes. That's the most common route that we imagine people are going to come here when they want to work in the UK. Employers wanting to sponsor people coming on a UK skilled worker route will need a sponsorship license. Existing Tier 2 general visa licenses will then be converted automatically into a skilled worker license, and the existing Tier 2 general visas will continue to be valid until they're extended or holders apply for a settlement or apply to come as a skilled worker. Now, the best news, I think, probably for employers is the end of that awful resident labour market test. This was just the bane of everybody's lives. As you know, up until today, basically, I appreciate that lots of you won't be watching this today, but for me today, if people wanted to employ people on the old Tier 2 general route, then unless it was a shortage occupation or on the shortage occupation list, you would need to go through the resident labour market test, which was relatively onerous in that you needed to show that you had advertised the role within the UK in set ways. Basically, you're showing that there wasn't somebody already here who couldn't fill the role. Well, the good news is, as I said, that that's now gone, and I know that that'll be a relief for a lot of employers. The 12-month cooling off period has been removed. This means that Tier 2 ICT holders can switch into a skilled worker visa from inside the UK at any time for their existing sponsor or a new employer. They can apply in the UK without having to serve a cooling off period outside the UK, holding a high earner job offer, and the employer having to conduct, obviously, the resident labour market test. The cap on overseas applications has been suspended. So that's basically, as you probably know, previously with certificates of sponsorship, there was a limited number each month that was released sporadically during or regularly rather throughout the year. Well, now that specific annual cap has gone, and so really it will just depend whether you fulfill all of the criteria. The 6-year limit on visa duration has been removed. So now, provided the worker can show that they still have a genuine job there, then it can potentially be extended indefinitely if they don't actually apply for settlement after being here for 5 years. The minimum skill level for UK sponsored roles has been reduced from graduate level down to roles at the RQF level 3, which is basically A level equivalent. So that's going to include an awful lot more roles than was previously included. The minimum baseline annual salary has been reduced, as you see, from £30,000 to £25,600. However, you do still need to ensure that you comply with the appropriate salary level for a particular role. So often that minimum salary isn't particularly relevant because the specific role has a higher designated salary, in which case you do have to comply with the higher salary, unfortunately. Salary will mean guaranteed gross basic salary only, so bonuses, things like that, won't be able to be included. And for the first time, a certificate of sponsorship will need to include PAYE details for those being paid through that system. There's now going to be a sort of genuineness test, and the Home Office decision makers have to be reasonably certain that the role isn't a sham. My guess is this is to avoid things like bringing over friends and things like that through nefarious means by making out that there's a role there for them when it isn't really a genuine role. Okay, so intra-company transfers. This is effectively just the rebrand of the old Tier 2 ICT. Again, UK employers wanting to sponsor someone on this route will have to hold a sponsorship licence. And again, as with the skilled workers, any existing Tier 2 licences will be converted automatically to an ICT licence. And the Tier 2 ICT visa holders can extend the ICT up to the relevant cap period. So under the ICT rules, the minimum salary is going to remain at the much higher £41,500 or the going rate for the job. So there's no reduction here. And again, the minimum skill level is going to actually remain at the RQF, so degree level for ICT, so unlike with the skilled worker route. Anyone on Tier 2 ICT can switch into the skilled worker route inside the UK without having to go outside first. The high earner salary level for ICT has been kept, but it's then been reduced to £120,000 from £120,000 to £73,900. Applicants will not be granted permission beyond 5 years in total in any 6-year periods. That's unlike the skilled worker route. However, if you are a high earner, which as I mentioned has been reduced now to 73,900, then it is possible to stay in the ICT for 9 years in any 10-year period. The graduate trainee route is going to remain available for applicants that have worked overseas for a linked entity for 3 months or more. And sponsors of ICT visas will have the same restrictions on what can be treated as salary as skilled workers. So it's the basic gross, except that allowances such as London waiting or cost of living adjustments can be included in those circumstances. Okay, so these new changes have been kind of advertised as using this new points-based system like in Australia. Now, personally, the whole points aspect of this new system seems to include little real change to what we had before, because there was actually points there already and you gain points through similar things as you do now. But in any event, I'll take you through the new points and how you obtain them. So first of all, you need to have 50 points on this table. So basically you need to get all the points that are available on this table. So you need to have a valid certificate of sponsorship. So you need to actually be sponsored. You need to have an eligible occupation. So that will get you another 20 points. And you need to have the appropriate language level, which gives you another 10 points. In addition to these 50 points, you need 20 tradable points. This is where there's a slight bit of wiggle room based on salary and other criteria. Okay, that's a lot of information there, but I'll fly through it as quickly as I can because it is rather dry. But if you're looking at salary only, then you'll get the 20 points if the salary equals or exceeds both the 25,600 per year or the going rate for the occupation code. Then in all the following B, C, D, E and F options, the salary can be reduced either to a specific figure if you're looking at the minimum salary, or a percentage of the appropriate salary for that occupation. So for instance, if we're looking at option B there, if you have a PhD in a subject relevant to the job, then you will get your 20 points if your salary equals or exceeds both the £23,040 per year or is 90% of the going rate. So effectively having a relevant PhD means that the salary can be 10% lower. Although if you have a PhD, I'm not sure that you'd want your salary to be 10% lower, but there we go. And this is basically the same, but as you see, the figure drops the more that you bring to the table. So if you have a PhD in a STEM subject, then the minimum salary will drop to £20,480 or 80% of the going rate. And this is basically similar for all of these other roles, apologies for all these other salary types there and qualification types. So if you can fulfill one of those requirements, then you get your 20 points. So if I just go back to my previous slide, you get your 50 points there, which you have to have, and they can only be made up in that particular way. And then on this table, you need to fulfill one of the options and it gets you your 20 points, which gets you up to 70. Okay, so for all of those people who are already kind of sponsor experts, please feel free to go now. It's like one of those things where I'm about to do a trick and everyone look away now. But no, if you feel comfortable that you already understand how the visa process works and how the sponsorship license process works, then do feel free to log off now. But if you think that the rest of this would be quite useful, finding out more about being a sponsor, then please stay tuned, and that's what we'll move on to. Okay, so put very, very simply in this table, as you can see, the process is pretty much as follows. There's an online application. There's extensive guidance. Now, I can't emphasize enough how much extensive guidance there is. Basically, what I'm about to talk to you about now is the summary of about 250 pages of guidance. So I'm going to talk to you probably for about another 20 minutes or so, doing a very, very sort of short version of this really extensive guidance. But you do need to make sure that you do comply with that. Now, obviously, hopefully you would come to me and I'd be able to help you to do that, because I'd be able to take you through that process and ensure that you're compliant. Part of the application is that you have to provide certain documentation. Again, there's a large list of different documents that you need to provide to basically show that you are who you say you are and you're a legitimate organisation. You have to be able to show that the business has got HR process in place that will enable you to monitor the workers that you have there. And of course, you have to be able to pay the appropriate application fee. Before applying for a license, I would advise that you consider, first of all, who your key personnel are going to be. There's 4 types of key personnel, and I'll just run through them really quickly now. So you've got the authorising officer, who is effectively the most senior person employed in the organisation, who is responsible for employing the migrant workers and ensuring you meet your sponsorship duties. You then have a key contact who will be the main point of contact between the organisation and the Home Office. The level 1 user is the person who will use the sponsorship management system, or the SMS. It's effectively an online system where you provide the necessary information to the Home Office. And finally, you've got a level 2 user who can perform limited actions on SMS. The authorising officer, key contact and level 1 users all need to be named on the application form. They can be the same person, which in many cases they're very likely to be, or they can be made up of different people. So you could have the same person being the authorising officer and key contact, but a different level 1 user, depending on what you want the different people to do and be responsible for. You can have a representative like me help you through an application process. However, you do have to actually submit the application yourself. So I could help you prepare it, but you would then basically have to press the send button. The representative could afterwards be appointed as a key contact, so they could help you through the process and then be appointed the key contact, but they shouldn't actually submit an application for you, otherwise it's likely to be rejected. There's initial fees which are going to depend on the size of the organisation. So the larger the organisation, they pay the large fee, or a small organisation or charity would pay the smaller of those fees. You pay a separate fee if you're renewing an existing license, and I've given sort of examples here of the types of fees you pay, and you pay for each certificate of sponsorship that you assign. There's also a new premium service which has come in with the new rules, and the cost of that can vary from £500 to £25,000 depending on the type of service that you want. The £25,000 is obviously going to be a very bespoke sort of service where you'll have your own person who deals with you as a sponsor and that you can contact probably day or night, I'd imagine, at that kind of price. Whereas the £500 is purely a one-off fee to have your sponsorship licence application dealt with in 10 days rather than the usual 8 weeks. The fee for applying for a sponsorship license is actually paid for them to consider your application. So if it's rejected, you don't get your money back, unfortunately. So the application should only take 20 or 30 minutes to complete, provided you've got everything ready. Now that's the big thing, it's provided you've got everything ready, because what they're talking about there really is having all your documentation ready. Now, I can't emphasize enough how important it is to have your documents ready, because they do have to all be sent off within 5 days of you submitting your application. So clearly what you don't want to do is spend your 20 minutes submitting an application and then the next 4 or 5 days tearing around trying to make sure that you've got the documents collated correctly. When you're making your online application, you need to estimate how many certificates of sponsorship you're going to need for the coming year. Now, you can't just kind of, stick your finger in the air and guess. You do actually need to have genuine roles that you believe genuinely that you will need to sponsor. Okay, when your license is being considered, as I mentioned a little bit earlier, it normally takes about 8 weeks for your sponsorship license application to be considered, although that can be now expedited if you pay the £500 fee. And what they're really looking at is whether, first of all, if you're eligible, and second of all, whether you're suitable. Now, when it comes to being eligible, that's really looking at whether you are a genuine business who has a role that is suitable for sponsorship. And they're the main things to be saying that you are eligible for a sponsorship license. In terms of suitability, that's looking at whether or not you've got the HR resources to actually manage being a sponsor. In order to decide that, they may actually pay you a spot visit to check that you've got appropriate things in place. Now, in terms of appropriate things in place, that's going to be like proper filing systems, things like that, to make sure that you can keep records properly and be able to really keep an eye on your employee and what's going on with your, in particular, your sponsored workers. Okay, certificates of sponsorship. So this is once you've become you've got your sponsorship license, then you get your certificates of sponsorship, and these are what you then issue to your skilled worker so that they can make an application for a visa as a skilled worker. Effectively, the certificate of sponsorship is a database record which confirms the details of the worker and the job. It acts as confirmation that the employer actually wants to sponsor a worker, that they're satisfied that the worker can meet the immigration requirements, that the employer is actually eligible to act as a sponsor, and that the employer will abide by the terms and conditions on the sponsorship management system. There's two types of certificates of sponsorships. There's defined and undefined. Now, there always was the two different types, but now they're called defined and undefined. The defined basically covered skilled workers applying for visas from outside the UK, and undefined is skilled workers from inside the UK and coming through via other routes. So when assigning a certificate of sponsorship, the information that's going to be required is the route on which they're sponsored, the personal details of the worker, the usual work address, and an awful lot of information about the role. This is really to check that the role does qualify for a visa. So it does qualify as being a skilled worker. So there they're going to need the title, the job description, the start date, because they need to know when it's going to start from, obviously, and key is the salary. Now, one thing I would draw your attention to is that the appropriate salary rates for the different roles does change. So when you are applying for your sponsorship license, the appropriate salary rate for the role could be one thing, but by the time you're issuing the certificate of sponsorship, it could be another. So do make sure you are paying the appropriate salary to cover that role, and so that it is actually still eligible. Okay, when you are sponsoring a worker, there is the immigration skills charge, which is paid when you assign the certificate of sponsorship. The amount paid, again, is going to depend on the size and type of the organisation and the length of the employment stated on the certificate of sponsorship. So if the length is less than 6 months, then actually you won't have to pay the immigration skills charge. But thereafter, you pay a certain amount for the first year and an additional sum for each 6 months. So once you have actually got your certificate of sponsorship and you assign it to a person, they effectively get a number that they then use when they are making their own visa application. Now, there are a couple of requirements for the worker. The first of these is financial. Now, they cannot claim public funds, so they have to be able to show that they've got enough to support themselves until they start to receive a salary. This is known as the financial requirement or the maintenance requirement. Now, what you can actually do is say that you will meet that simply by ticking the maintenance box when you're obtaining the certificate of sponsorship. In terms of leaving and re-entering the UK, they can actually leave and re-enter for business, holiday or personal reasons as often as they want to, provided the entry clearance or permission to stay hasn't expired. In terms of your duties, so your duties as a sponsor start when the license is first granted and they end whenever your license ends. So if you surrender that license, if it's made dormant, or if it's actually revoked. Now, you have separate responsibilities to the actual worker, and they actually start on the day you assign the certificate of sponsorship. So not the day they start with you, but rather the day that you assign the certificate of sponsorship. Excuse me. Now, it ends when they no longer have permission or entry clearance, or if they start to work for a different employer. So they may you may be sponsoring them, but they find another job with another employer who's then going to sponsor them. The day they leave you and move on to work for them, your responsibility to them would end. Or alternatively, it would end when they settle or are granted permission to stay on a route that doesn't require your sponsorship. And finally, it would end on any date when you told the Home Office that you're no longer sponsoring them. So this would be, for instance, if they've actually resigned or you have dismissed them for any of the normal reasons that you may dismiss an employee. Okay, so once you've become a sponsor, you have certain duties. So you've got reporting duties, record keeping duties, you need to comply with relevant legislation, and you cannot engage in behaviour or actions that aren't conducive to the public good. So looking at each of these very briefly in turn, in terms of the reporting duties, this is using that SMS systems, that online reporting system, and this would be a level 1 user, would need to be the person who'd report certain things. Now, types of information that would need to be reported, and this is not a full list by any means, but would be things like if the employee failed to start on the first day, or if they were absent from work for 10 or more consecutive days without permission. So basically if they went AWOL, if they were resigned or were dismissed, because obviously you need to let the Home Office know that you're no longer sponsoring them to be working here in the UK. If the sponsorship stops for any other reason, or if there's any significant change to their employment, such as promotion or a change in their job locations. If you move them to a different site locally, you'd still need to let them know, because do remember they may want to come and pay a spot check, so they clearly need to know where that person's going to be. There's also changes that you would need to report, but then within 20 days that relate to your business. So that would include if parts of the business were sold, or something along the lines of changing the names of the business. So basically, details to do with the employee should be reported within 10 days. Details to do with the business itself should be reported within 20 days. And that should all be done on the SMS system via your level 1 user. So this is a final slide, final point. The record keeping duties is basically that you need to keep a clear record of all of the workers that you are sponsoring. So it's basically showing that they are a genuine employee with a genuine role to work in, and you need to be able to show that you've kept a clear record of this, and you need to be prepared to provide any documents required by the Home Office. As I've already mentioned, it does need to be kept in a proper system, so it's not going to be appropriate to have in a box shoved somewhere. You will need to show that you've got appropriate HR procedures in place to keep those records. You need to comply with both immigration legislation and other UK legislation. So examples of that are obviously going to be that you are employing people in appropriate roles and paying the appropriate salaries. That would be complying with your immigration legislation. So if it's not a genuine role, for instance, that would be non-compliant. Equally, complying with UK wider legislation would be something like paying national minimum wage, ensuring your staff has the right holidays. If, for instance, as a business, you need a license to function, then it will be being able to show that you have the appropriate licenses in place. And effectively, behaviour that's not conducive to the public good is being able to show that you do behave in a manner that is consistent with UK's fundamental values, so that you're a decent employer, you're not inciting hatred in the community, that kind of thing. Now, this has been a bit of a flying visit to a sponsor and a sponsor's duties. There's a number of areas that I haven't covered today, and I'd be more than happy to do so. So if you feel that something that would be of specific interest to you hasn't been addressed today, please do get in touch and let us know what you would like to be covered by way of business immigration, and I would be happy to help. So for instance, if you felt that you were an entrepreneur and you wanted to start up business here, but you wanted to know how, please do contact me. These are all things that I can actually help with. Equally, as an employer, other areas that maybe we haven't covered today and you might be interested in is if you are a public sector employer, there can be some separate rules, in particular if you're employing, say, nurses or midwives. Other areas not touched on today is what happens if, for instance, an organisation is TUPE'd or subject to the TUPE regulations, or alternatively, if unfortunately a business that was a sponsor went into administration, what would happen in those circumstances? Now, I just want to let you know that these are some of the other things to be aware of and that haven't been addressed today. It may be that they're not particularly relevant to you, but it might be something that you're like, yes, that's what I really want to know about. Now, if that is the case, please do just simply drop us a line and let us know what else in the business immigration area you would be interested to hear about or to have another webinar on, and we'd be happy to do it. So thanks ever so much for joining me on this flying visit to the new business immigration rules, and hopefully I'll get the chance to see you all soon.
Thanks, Fiona. Just very quickly for me, we release webinars, podcasts and blogs on a regular basis, all of which can be found on our website, www.sintons.co.uk, should you wish to take a look. And you can also follow us on Twitter at SintonsHR. If you'd like to discuss anything that Fiona has raised today further, please don't hesitate to get in touch with her. She can be contacted via telephone 0191 226 7878 or via email fiona.campbell@sintons.co.uk. That's all from us. Thank you very much for listening, and we look forward to speaking to you at our next session. Thank you.